go better. I'll make it go better.
All right, don't rub it in, everybody. It's Thursday before a long weekend, and those of you with normal lives will do that. You'll take Good Friday off. You'll have a picnic with the family on Easter. You'll have 3 wonderful days, and then you'll come crawling into the office on Monday morning like zombies after a bloodbath. And I'm talking about sating yourself on blood. You'll stagger into the office. You know, I mean, I used to sit outside the New Haven courthouse on Monday and watch people straggle in. It's like, wow, you know, the new arrestees were stunned by the majesty of, or the tragedy of it all. The lawyers were like, oh, here we go again. The judges were like buttoned down, but everybody was drawn to the courthouse by the silent rhythm of human suffering, and those who made their living off of it, you know, sat back and said, take, eat, you know, this is my body. And I'm like, holy cow, I don't want to give it up some days. Anyhow, welcome back. It's Thursday. Thanks to Eric Huntley, did a nice interview with me. It's published on something or other. I think we've got a link to it. I haven't watched it, but it began well. He had glowing accolades about me, and I'm like, every time that happens, I'm like, I better not say anything. I don't want to piss it away. But nice comments so far. Take a look at it. Spread the word. Drive people to LawPod Daily.
We don't have to glide past it too fast. Here it is. I'll get Julian.
Oh, what a handsome guy he is, Eric. That is, yeah.
That's
truly legendary trial lawyer. There you go. Yeah.
Well, I think that Eric, you know, is a pretty impressive dude. He's got several YouTube channels, but he is also the gentleman that runs Laid Back Law every Friday, and that's where we appeared almost a week ago, and then he had you on earlier this week, and then that was published last night. I listened to the entire interview, Norm, and I think, you know, one thing that I'm struck by, well, 2 things that I'm struck by. One is that how genuine of an interviewer he is. I really liked listening to this interview. It was very well organized. He was keeping to his, you know, discipline, trying to get from topic to topic, but he was not losing anything in terms of absorbing the stories that you shared and the lessons that you had taken from your own travels through life. He was responding in a genuine way and asking follow-up questions that I thought were just amazing to see, that sort of patient conversation and involved conversation. Typically these things can kind of be a little disconnected, 2 ships passing in the night as an interviewer asks a question that they're not really listening for an answer, right? And then the second thing, Norm, is I'm always reminded when you do these sorts of things of just how truly and objectively impressive that your career arc has been, and your capacity to navigate your own emotion and your EQ, as I would call it. It's your roots inform a lot of who you are today, but your ability, and I know that you talk about how much money you've spent in the pursuit of therapy and all sorts of other stuff in the latter years, especially representing more high profile clients. But what I appreciate about your story is not so much what the story is, but your ability to draw meaningfully and productively from it. And that's on full display in this interview. So if you haven't listened to anything from Eric Huntley, do him a favor, go subscribe, and then watch this video. Leave him a like and a comment. And the comments over there are glowing, Norm.
And in case, and once you've done that, in case you haven't had enough, I've already given an interview this morning for 45 minutes or so that'll be displayed on WABC's The Other Side of Midnight with Frank Morano. It appears 1 a.m. to 5 a.m. It's an all-night coast-to-coast show on WABC radio. Frank interviewed me about 12 years ago. He finally got around to reading one of the books I wrote 12 years ago and wanted to interview me about it. So we talked about juries and justice, and so take a listen. 77 WABC, The Other Side of Midnight. Frank Morano. I'm told that taped interview will be on tonight or tomorrow morning, I guess, as the case may be. So, you know, enough of this nice stuff.
Welcome, been there, done that. Thank you for being here.
Share. Yeah, thank you. So, you know, yesterday, I did some more stand-up, this time in Bridgeport at the Stress Factory. And, you know, I've got more than my 10,000 hours, to use Malcolm Gladwell's line about time on your feet, but not as a comic. I'm told that I've got presence. I need to develop my material. And so it was fun to be on the stage. The acoustics weren't what you could hope for. Small crowd, perfecting my craft, looking for another opportunity to appear. I'll probably go there next Wednesday night as well. It's open mic every Wednesday. But on April 4th, I'll be speaking to the New Haven Ladies Association or something. I don't know about the use the banning of public statuary in modern political time. Can you hear me? My screen is frozen up. Are you able to hear me, Mike? Okay, but I'm getting ready to do stand up. I'm working my material. I'm living the raw life right now as a guy, recently out of a long-term marriage and, is trying to find my place in the world while managing a high-profile law practice. And you're thinking, and podcasting and doing stand-up? And I'm like, yeah, there's a lot on my plate. But so I'm having that day and I'm coasting and feeling like, I'm doing pretty good for an old man in medias res. That is in the middle of things. When I get the following email. And, normally, it raises the following question: who are these haters? And what is the satisfaction to be derived from hating a person you never met? I don't know who this guy is. Mark A. Potok at gmail.com. I don't even know that he is. I don't even know that that's his actual name. From the dark hole of hate, this missive arrives. I posted on Twitter. You may or may not be a voice for freedom. That's what one of my websites says. But I just watched the new HBO documentary on Alex Jones, and you're a moron? Well, I don't think that's true. A terrible lawyer? I know that's not true. And obviously a terrible human being. And I'm thinking, did my soon-to-be ex-wife write that? Because, it sounds like the kind of thing that a hater would say. Thanks for making the world a little worse. Alex Jones is a piece of shit and you're his advocate. So I submit this to you as a forensic exhibit. And I ask the following question: what in the hell is the matter with Mark Potok? Even if I am everything that he says I am, a moron, a terrible lawyer, and a terrible human being, okay, there are probably about 7.8 billion others of us wandering around in the world, and he's not sending him hate mail. I get a lot of this, and yesterday I just didn't need it. At the end of the day, it was a buzzkill. But I'd be curious, those of you who are in the comments section, what do you make of these guys? And not, don't characterize them. I see freedom lovers comment, Mark is an asshole. They hate us because they ain't us, Luttrell says. MSM watcher asshole, self-absorption, Maury says.
Yeah,
these are all characterizations.
Points out that, and I see a Mark Potok as a former senior fellow of the Southern Poverty Law Center. I was able to locate that online. Jackson, you're saying the same thing. You say Southern Poverty. Lawyer Will says Mark Potok is on X at Mark Potok, and he posted the same email from that account. Let me see. I'm going to click this link, Norm. We'll see where it goes. I may be able to bring this up.
But it just, so here we got a guy at the Southern Poverty Law Center, trying to make the world a better place. And he somehow thinks that this is a wise and appropriate investment of his energy.
Well, look, there he is. He's saying, yada. There you go. Right.
Well, I don't know. Your
Will sleuthing. Thank you, buddy.
What is it about the internet that makes us into gratuitous and self-righteous and vindictive moral censors? I don't understand that. So, Mark was not the basement dwelling creep that I assumed he was. He's a person with some significant institutional attachment. So now I know I'm hated by a former member or perhaps member of the Southern Poverty Law Center. Why? I mean, do you have any idea why?
Yeah.
Mike?
Yeah.
Tell me why.
Well, so I think I sent you a note yesterday that just said someone watches an HBO documentary and their next move is to send you an email. I don't know that you need to read very much past that, right? All of the qualifications, you know what I mean? So just generally speaking, Mark is a loser. And that's not me projecting him. He's obviously a loser. He thinks that of himself. He doesn't think very much of himself. He doesn't believe that he would never have the courage. He would never be able to summon the courage to do something that the world would look upon in mass as unpopular, right?
Mm.
Or represent somebody who is pilloried in the media, pilloried by the justice system, or have the stones to take on something where the likelihood of success is unknown at best. Mark is
Yeah.
a loser. Don't be Mark. Mark, if you're
Yeah.
listening to this, you're a loser.
Well, Mark, send me another note. Love you, dear. What I should have done is what I customarily do and ignore it and just say, I'm not going to pay for the space I occupy in someone else's head. But I paid for it yesterday. And I'll be honest with you, it hurt. And rather than strike back out and react in true to form, part of my stand-up routine, I get haters. Guy chants, I hope you die of ass cancer. I look at him and say, why would I want ass cancer when I have you? And so, Mark, you fit into the ass cancer category today. Get yourself some treatment. Go to a social oncologist. Better yet, bend your knee in prayer and ask the Father and recite the Lord's Prayer. Forgive us our trespasses as we forgive those who trespass against us. Because as the Apostle Paul once said, all of us have sinned and fallen short of the glory of God. Yeah, but Coltrane, you're on a roll today. Probably got therapy from Jody Hilbrandt. That's the mommy blogger's co-therapist. They starved the kids to death. So let's move on. Enough of this.
Lawyer Will says, have him on the law pod. The conflict would be great. It's not a bad idea.
I don't know about that. Hey, so let's move on. So interesting email from a longtime listener of this podcast and the radio show. I had Glenn Wolfe. And, he raises a dilemma that every seasoned criminal lawyer faces at one point. What do you do if somebody confesses a crime to you? And I don't know. Are we able to blow this up?
Yep, got it up right now. So it says, you received this and you sent it to me. I just kind of screen capped it. Norm, consider the hypothetical. I have committed a truly heinous crime, and I engage you or your firm proactively because I fear I may be charged. As part of the consultation, I admit to you I did said crime. You are so disgusted that you can't help but report me to the police. Is this evidence inadmissible because it violates the attorney-client privilege, or is it admissible, but in reporting me to the police, you have ruined your reputation as a lawyer and now struggle to find new clients?
So first, let's consider what it is to represent a person accused of a crime. The law has a presumption of innocence, which means that at the moment the state makes an accusation, the person is presumed innocent. They are regarded as innocent unless and until something more happens. And that something more is the state proving its allegations beyond a reasonable doubt to a jury's satisfaction or a judge, depending on how the case unfolds. A person can obviously enter a plea and admit that they have committed the crime they've been charged with. That would be a guilty plea. But realistically, when a person walks into your office and admits that they've committed a crime, that is subject to the attorney-client privilege, and it is not your role to report it. If you do report that crime, you've violated the privilege. And candidly, I've never had to litigate a confession to a lawyer where the lawyer came forward to know whether it can be suppressed. Arguably, it's not a Fourth Amendment violation, which is where the suppression remedy is most typically applied. In other words, the Fourth Amendment prohibits the seizure of the unreasonable seizure of things. And when things are seized unreasonably, they can be suppressed. Okay, I get that. The violation of the attorney-client privilege is not rooted in the Fourth Amendment. And so arguably that lawyer could be called to the stand. I think that a good defense lawyer would move to strike that testimony or not permit a jury to hear it on the grounds that the client's right to an attorney-client privilege is so fundamental and grounded in to the attorney-client privilege in our legal system that to permit this to happen would be a violation of something sacrosanct. That is the role of secrecy in the relationship between lawyer and client. Having said that, I can see arguments on both sides of the admissibility factor, and I guess I need to look up some case law because I'm sure this has happened before. But were I a trial judge, I would not permit a jury to hear that I would refer the lawyer who violated that rule for discipline and perhaps disbarment, because in violating the attorney-client privilege, you've taken something fundamental and ignored it in ways that hurt a client. The purpose of the privilege is to permit lawyers confidence that what they tell you will remain confidential unless and until they waive that right, so that knowing what their perspective is, meaning the client's perspective, the lawyer is best able or better able to defend them. And so, it can put the lawyer in a tough place. Most criminal defense lawyers don't ask their clients, "Did you do it?" Because you're not supposed to knowingly put on false testimony. So, a guy comes in on Monday, accused of murdering the cab driver. I did it, he says. And then on Tuesday, he tells you, I was in Toledo. Well, which one of those is true? And, maybe neither. And so I think that you don't want to be in a position as the defense lawyer necessarily of knowing too much too soon. Realistically, you want to know what the state's allegations are and discuss them with the client so you can sculpt a defense. Now, the spider sense in some of you must be activated at this point, and you're saying, why do you do that? Do you do that so the client can sculpt a better lie? And there are lawyers who do that. And I'm telling you, at the knife's edge of the criminal law, these are the ethical dilemmas that you face every day. I've had clients say to me, upon my telling them what the state's allegations are and what the nature of the state's proof is, well, how should I respond? And my response is always with the truth. You don't lie. You don't overstate your case. You respond to the questions that are put with candor and decide whether to testify or not. More often than not, criminal defendants do not testify, and they do not testify either because they have in fact engaged in some form of misconduct that might look like the crime, because they are not a good witness, because they're too nervous, or maybe they don't know anything. And exposing you or your client to cross-examination gives the state an opportunity to tell its story through the witness. So let me give you an example of this in a civil context. Many years ago, I was involved in a police unreasonable force case where about 20 cops turned up at a house party. And somebody got banged up by the cops. And so they sued. My former partner sued every cop who was present at the scene, all 20 of them. And maybe 2 of them laid hands on the person, and the other 18 were otherwise involved. And probably 15 of them didn't even know what happened. So we hadn't taken depositions of the cops. We just went to trial. And cop A, banged the guy up. He had his story about why it was justified. Cop B helped A. C didn't say anything. D didn't say anything. And when I got to E, F, and G, I'd call him. I called Mike Boyer to the stand. Were you present at the household at 123 Main Street on July 4th, whatever year it was? Yes. Let's just cut right to the chase. I'm guessing you didn't see anything. Is that right? And he said, yeah. And the jury started laughing at these guys as I did this, because I created the impression that they were lying about having seen nothing. It might have been the truth. And as my client's advocate, my job was to make the best case for him, and I did. Now, years later, would I do that the same way now? I don't know. This is a decade of reckoning for me as I round third and head for home in my legal career. And I wonder, whether some of the risks I took as a young lawyer are risks I would take as an older and wiser lawyer. But why is this segment called the Jimmy Hoffa rule? It's called the Jimmy Hoffa rule for a reason. You will remember that James Hoffa was the head of the Teamsters, and he disappeared, I think, in the 70s, and his body has never been found. And people like to speculate, about where Jimmy Hoffa is buried. Now, not all of you know who Jimmy Hoffa is. I'm reminded of this because I mentioned Jimmy Hoffa at a stand-up discipline or argument in a stand-up workshop in LA not long ago. And it was in one of these telephone game things where a person creates a sentence in a story, passes it along to the next person, and the group tells a story. So I mentioned Jimmy Hoffa, and the kid didn't know who Hoffa was. They thought it was Hoffman, and they didn't know who the Teamsters were. And I'm like, okay, don't assume too much knowledge.
Wow. How is that it? Recognizing that, Norm, how did that feel? Right? Isn't that seems wild to me, but I'm also of that generation, and it has to be wild to you.
It made me realize that truths are to be shared. and that
Right.
communities are built around shared truths, and the process of passing information in the baton is infinitely complicated. As I talk to you now, it reminds me of why I was excited to hear Nicole Shanahan yesterday, RFK Jr.'s new candidate, because she is engaged in this generation and this new generation, and is a bridge between generations, and we need to foster that communication. But anyhow, as to the Hoffa rule, this finally gets to Glenn Wolf's question. A lawyer, a client coming into his office can confess to anything that they did before walking into the office, and the lawyer's responsibility is to keep that secret unless it's waived. There are narrow exceptions, but not many. What a client cannot do is ask the lawyer's assistance in covering up the crime or committing another crime. So the Jimmy Hoffa rule is, come in and tell me that you killed Jimmy Hoffa. Come in and tell me where you buried his body, and I will keep your secret to the death. Come into the office and tell me you killed Hoffa. He's in the trunk. Can I help you get rid of the body? That would involve me in a crime. And at that point, I would have to say, no, I can't do that. Now, would I have an obligation at that point to go to the police and say, this client came to me and asked me for his assistance in disposing of the body? And isn't this high profile, shocking, heinous crime the sort of crime that raises Glenn Wolf's hypothetical? Shouldn't I go to the authorities with that? I still think the answer is no, because the balance tips in favor of the attorney-client privilege. So I think, and I've been in this position, candidly. I had a client come in once to see me. He says, some people are messing with my mom. They threw a brick through her window last night. I said, I'm sorry. Is there anything I can do for you? I was surprised he came to see me. He says, yeah, how do I kill them and get away with it? And I looked at him and I said, I can't give you that advice. Who told you? And then my paranoid gene was activated. And I said, did the feds send you in here? I made him lift his shirt to see if he had a wire, because it was such a preposterous question. It struck me that he was clearly looking to set me up. And he was just being naive. You go to your lawyer for advice. Who are you going to ask how to kill somebody and get away with it, other than a person who has successfully defended murder cases? So the Jimmy Hoffa rule is a rule about time. When a client comes to see you and confesses to something that occurred even 1 second ago, that is sacrosanct. When he asks you to help him cover up what happened a second ago, or to commit some future act, that's not. But the lawyer cannot be engaged in that counsel. Somebody else here
making this really trying to make this even more complicated.
It's not, Maury. Letters of engagement aren't magic. If a person comes to see me for purposes of consulting me, I don't need a letter of engagement to be bound by the rules of professional conduct. You come in and say, I killed my husband, and that's privileged. You don't need a letter of engagement for that. There's also this old canard, that somehow you have to pay a lawyer $1 at least, in order for the attorney-client relationship.
I had so many old heads try to do that with me, just joking over the course of my life. Like, hey, okay, now you're my attorney, right?
Yeah, no, it takes a lot more than $1 in my life, let me tell you. So, that's the Jimmy Hoffa rule. That's a little bit of a discussion about these issues. There is what's called the crime fraud exception to the attorney-client privilege. And so, if a client seeks to engage you in commission of a crime or a fraud, you actually, I think, can go to the authorities, because that's not privileged. I just wouldn't do it. I think that there's a duty of loyalty to the clients. Glenn Wolf's question raises the question, suppose the crime were truly shocking, horrid, and controversial. I still think there are times where the right thing to do is to bear your client's secrets even to the grave, regardless of the cost to your peace of mind. Lawyering.
Go ahead. Sorry.
Lawyering is a lot like being a priest. It's a service vocation, and sometimes the secrets you carry weigh you down heavily.
Well, I was going to ask a really important question, and that is, have you seen The Irishman, the movie?
Oh, yeah. It's a great movie. I love it.
Okay. Yeah. So Lawyer Will over on Rumble reminds us that the Scorsese film from, I think it's on Netflix as well, if I'm not mistaken. So you don't have to have, you don't have to pay an additional something for an obscure platform. But The Irishman, that's Al Pacino, Robert De Niro, and that is he's the protagonist in that. Al Pacino plays Jimmy Hoffa, and interesting times. I think that we were kind of debating over in the Rumble, not really debating in the Rumble chat, but um, lawyer Will says that Hoffa is not obscure, and while I agree that his name is not necessarily obscure in American culture, certainly the meaning of his movement within the Teamsters and that era of American industrialism and then collectivization and the growth of union power and leverage and influence in politics is not very well known or appreciated by younger Americans today.
Well, I think, I don't know what people study when they study American history. I don't know how American history is taught. I think, the Spanish philosopher, I think it might have been Unamuno, another Spanish philosopher, who said, "I am I in my circumstances. If I don't change my circumstances, if I don't save my circumstances, I don't save myself." And so I think our history is our collective past, and it's what gives us a sense of continuity over time. And we study history so that the present sense impressions we have of the world around us make sense in terms of a larger world. But we've almost talked our way through the time, and I've once again filibustered you away from this topic you're just burning to talk about. So let's get to it.
I'm burning less and less. I really don't. I don't like talking about this issue, mostly because I can't wrap my head around. Well, I can wrap my head around it. I'll be very frank. I think that the learned helplessness among younger people in America is a real problem. But so is the ignorance as to the fruits of one's labor. Here in North Carolina, in our Constitution, we have what's known as a fruits of their labor clause, and what that is, poetically designed to instantiate is an inherent recognition that the individual is sovereign and the individual therefore owns his or her own labor and may therefore negotiate and barter and contract for terms surrounding that labor, right? And so North Carolina is a right to work state. This is not a union state. And I've grown up in this environment, and therefore I am biased against unions, generally speaking, for that reason. I think that North Carolina is the center of the known universe. That's well documented and more true now than ever. But when it comes to the mechanism known as the non-compete, right now there is a lot of discussion online and in the FTC as well here about the constitutionality or potential lack thereof of what's known as a covenant not to compete or a non-compete. So Norm, what I'll do here quickly, rather than trying to get into sort of the cultural argument, is just unpack what a non-compete is. A non-compete is a provision in a contract, usually for the provision of services, and it can be as an employment relationship or even an independent contractor relationship. Attorneys have a version of non-competes built into their attorney-client relationships, right? We call those conflicts. Essentially, non-competes are covenants that an employer will ask an employee to honor that restricts the time, territory, and scope of that employee's work if they ever leave the company. And so I say time, territory, and scope because those are the three vectors that non-competes exist upon, right? How long is a potential non-compete is relevant for adjudication of its legality. And the scope of the non-compete, meaning what are the various aspects of the employment that are being restricted outside of the boundaries of the company. And then territory, literally geographically, and then in terms of an internet era, it becomes a little more complicated, but territory, how far reaching should that non-compete be active? Here in North Carolina, the time for a non-compete, generally speaking, is regarded as being not more than 2 years, but we're also a blue pencil state, Norm, which simply means that if there is a non-compete drafted and a court adjudicates that the non-compete is somehow unlawful or exceeds what is fair and equitable under the circumstances, that the court will rewrite the non-compete to make it make sense. And so when we discuss these things right now, the conversation and the reason we're even talking about it is because there is a groundswell of criticism about the non-compete as a legitimate mechanism that businesses may deploy to preserve their market share or to preserve their resource allocation and investment in the business, in the underlying business, the growth and the necessary risks that businesses need to take in order to get to the next level. Right now, I'm not here, and I'm not, I'm not unwise when it comes to the excesses of non-competes, but I'm not unwise in the same way that I'm also aware of the excesses of collectivized labor unions as well, right? So we're not talking about stuff on the margins, right? At least from my perspective. What we're talking about fundamentally is the ability for people to negotiate for their labor. So for someone like Lena Khan, who's I think my age, maybe a year older or younger, who has no life experience in the business world. She's never built anything, right? She's never employed people. She doesn't understand at all the mechanics of business, but she is the chairperson of the Federal Trade Commission, which oversees federal labor standards, right? And the issue that I have is that when we discuss these things about non-competes, they're always a hindsight analysis, right? That the criticism of non-competes or the people that bind their employees to the non-competes are inherently evil for ever even wanting to restrict what that employee may go and do outside of the confines or the boundaries of the relationship with that employer. I think that's completely ludicrous. I think that there are plenty of reasons to want to enforce and uphold non-competes. And I also think a slippery slope exists that is not being discussed, which says that if we get rid of non-competes as a constitutional mechanism in contracts, what of intellectual property thereafter? Right? Things like patents and copyrights and trademark registrations, et cetera. So anyway, that's my quick spiel. I know that I want to make this more of a journey. We'll continue talking about this stuff. It's a hot topic in beer. It will be for years to come because beer is very progressive and left leaning, at least in the craft space.
Beer is progressive and left leaning. What is wine?
That tends to be more right leaning.
And hard liquor?
Well, I'll say wine doesn't actually tend to be more hard leaning anymore. It was at one point. Now wine is very much sort of the elitist, corporatist left. And hard liquor and spirits, it tends to be more right.
All right. Well, hey, so, we've talked our way through another 30 some odd minutes of your life. Thanks for coming to Law Pod Daily and Law and Legitimacy. We will be back tomorrow with another exciting adventure of As the World Turns, or whatever this melodrama is. We look forward to your comments. We look forward to your suggestions on what to cover. And we look forward to following us. You're following us and spreading the word that we're out here. We've now made the advertising threshold for YouTube, and we're on our way toward trying to create an independent platform that permits both of us to give more time to exploring the issues you want to hear about in ways that others don't, because we have, because we're right and everybody else isn't. And you know that now because you've been listening for more than a week. So thanks for listening. We'll talk to you tomorrow. Mike, how do people find us?
You can find us on YouTube at LawPod Daily. You can find us on X at LawPod Daily, and not to neglect Rumble. You may also find us over there. Some of you may actually, you may actually see that I invested some time and some effort and made our little header over there on Rumble look a little better. And I'll start paying attention to editing the videos after the streams. And again, I still think that Rumble has a ways to go. But and yeah, Norm, you've been frozen most of the time. I think that our hardened core of people that come to the streams every morning know that tech issues aren't necessarily what define us, but they don't, they're not exactly irrelevant either. But we'll get that figured out. If you're over on YouTube, please go ahead and give us a subscribe, enable the notifications, and we are going to begin building out more of some organization over there on YouTube. I was looking at it this morning, Norm, and I just think it's hilarious. Seeing ads roll on our videos is very funny. So, we have to get, hat tip to us for joining the top.
Hat tip to you. I didn't have anything to do with it.
No, I mean, we joined the top 1% of all content creators on YouTube. So therefore, you, the viewer, you are watching elite content. Congratulations.
We ain't nothing but elite hound dogs. Nothing wrong with that. All right. Well,
thank
hey,
you for the compliment. Thank you everybody for being here. Norm, we're going to get you unfrozen. I can't look at you just, pause like that anymore.
Well, folks, what happens? What do you call it when you're frozen on a video content screen? That's a virtual obit. I don't want to read mine, so I'm getting out of here. I'm heading to court. Objection, everyone. And what do we say at the end of each episode? AMF yo-yo. So AMF yo-yo, you're on your own, and off we go into the wild blue yonder. Talk to you tomorrow.
See everybody. Thank you, Norm. See you tomorrow.
Yep, bye.